Thank you so much, Ms. Wells. I will call this hearing this committee to order. Today is March 15th, 2021, and I will ask the esteemed secretary to please take the roll.
Vice Chair Cannizzaro.
Here.
Senator Orenshaw.
Here.
Senator Harris.
Here.
Senator Settlemeyer.
I'll ask that you mark him present when he arrives, and I'll try to make a record of it too.
Senator Hansen.
Here.
Senator Pickard.
Here.
Chair Scheibel.
Here. Thank you. And we also have with us Mr. Pat Guinan from the Legislative Council Bureau. As has been the case for a while now, we are missing Nick Anthony, our committee counsel, but he remains available to us for legal questions while he continues to draft bills. And we have a couple of items on our agenda today. We have one bill hearing. We do have a BDR introduction, so I want to make sure that everybody received that BDR by email earlier today. If you could give me a nod in one direction or the other. Okay, it looks like you all received it, so we will do that after the bill hearing and then public comment. And since I am presenting today, it is my pleasure to hand the metaphorical gavel over to Vice Chair Cannizzaro.
Thank you, Chair, and welcome members of the committee. We've got one bill on our agenda today. It's Senate Bill 166, which revises provisions relating to crimes motivated by certain characteristics of the victim. And we are welcomed and joined by our chair, Senator Scheibel. And we will turn it over to you, Senator Scheibel, to go ahead with the bill presentation, and then we will take questions from committee members whenever you're ready.
Thank you so much. Good afternoon, Senate Committee on Judiciary. My name is Melanie Scheibel, and I am the Nevada State Senator for District 9. Thank you for your time and attention as I present Senate Bill 166, which provides technical changes to statutes regarding crimes motivated by hatred or bias, commonly referred to as hate crimes. Before I explain what the bill does, I want to be very clear about what the bill does not do. It does not change the definition of a hate crime, expand the classes of people protected by our hate crime statutes, or change any penalties for committing a crime motivated by hatred or bias. Please note that I have submitted a conceptual amendment for the bill, which was posted on Nellis on Friday, and I will be working from that conceptual amendment in my presentation. I'll start with Section 1 and explain what it does. Senate Bill 166 takes two existing statutes related to hate crimes, NRS 207.185, which relates to misdemeanors, and NRS 193.1675, which relates to gross misdemeanors and felonies, and aligns the language between the two. To illustrate why this is important, I'm going to provide a very realistic example, and I've also provided a sample verdict form to go along with my explanation. I know that it can get, we kind of get into the weeds here. For those who practice in criminal law on a regular basis, this may be your bread and butter. For those who don't, this is highly technical, but I think it's incredibly important. So let me explain, first of all, how we charge crimes like battery. A simple battery is a misdemeanor. It's punishable only by 0 to 6 months in jail. It does not carry all of the associated penalties of a felony, but it is defined as the unlawful touching of another person, okay? So common battery crimes include punching somebody, shoving somebody, pushing somebody, kicking somebody. Those would be misdemeanor batteries. A battery can get escalated to the level of a felony if there are other facts in attendance. So, for example, if the battery causes substantial bodily harm, then the battery gets elevated from a misdemeanor to a Category C felony that carries a possible sentence of 1 to 5 years. Substantial bodily harm is well defined in law. It is any permanent disfigurement or prolonged physical pain. So that same act, which was previously considered a misdemeanor, punching somebody, kicking somebody, shoving somebody, if the result is that they break their nose, they break their jaw, they have a permanent scar on their arm, that action would then be considered a battery causing substantial bodily harm. The person who determines the difference between a battery and a battery with substantial bodily harm is a jury or a fact finder. The same thing is true if we're talking about a deadly weapon. The same act that is committed with just somebody's hands, if they commit it with a baseball bat, a knife, a gun, becomes a battery with a deadly weapon. And so coming from that one nucleus of operative facts, the one battery that occurred, that same crime can have those other attendant circumstances of causing substantial bodily harm or being done with a deadly weapon. And both of those elevate the level of the crime. A battery with a deadly weapon is a category B felony, carrying a sentence of 1 to 10 years. It's also possible, and in fact, it is common, that a battery is committed with a deadly weapon and causes substantial bodily harm. So when the jury hears the facts of a particular case where the state is alleging that the defendant has committed a battery with a deadly weapon resulting in substantial bodily harm, the jury has to evaluate all three of those questions and ask whether or not a battery occurred, whether or not substantial bodily harm occurred, and whether or not the crime was committed with a deadly weapon. And then they have the option of any of 4 verdicts. Well, 5. They can find the person completely not guilty. They could find them guilty of battery with a deadly weapon, battery causing substantial bodily harm, battery with both a deadly weapon and causing substantial bodily harm, or just a battery. All of that goes on one verdict form. And we know that the lowest level is only a misdemeanor and the highest level is a felony. But we don't convey that to a jury because we don't want jurors to make their decisions based on the level of punishment. We want jurors to match the law with the facts and tell the judge what they believe happened, which elements of the crime were met. So it all works as long as we're not talking about adding an enhancement for bias or hatred. When you add the enhancement for bias or hatred, there becomes a problem in that NRS 193.1675 and NRS 207.185 have different wording. In order to prove that the misdemeanor battery was motivated by hatred or bias, it is only necessary to show that it was that the motivation behind the crime was the victim's perceived or actual race, color, religion, national origin, physical or mental disability, sexual orientation or gender identity, or expression of that person or a group of persons. That's what elevates a misdemeanor to a gross misdemeanor. The problem is that on the felony side, to substantiate a claim that a battery with substantial bodily harm or a battery with a deadly weapon or a battery with both was motivated by hatred or bias, the definition is different. That definition reads, because of actual or perceived race, color, religion, national origin, physical or mental disability, sexual orientation or gender identity or expression of the victim was different from that characteristic of the perpetrator. Because those definitions are different, it doesn't allow a jury to pick between all of the available options to them. A misdemeanor enhanced by hate, a felony enhanced by hate. It means that you have to either divide the verdict form into 2 separate crimes, or you have to simply choose one definition or the other and ask the jury to determine whether or not hatred or bias was the motivation of the crime at one level, but you can't show it at both levels at the same time because the definition is different. So what this bill does—
Senator,
Yes.
I hate to interrupt you, Chair Scheibel. However, it looks like we may be having a few technical difficulties with the video feed. So we've been able to hear you audio via, I think, everyone in the committee room, but then also publicly. But I think we're having just a little bit of a technical difficulty with video. So I'm going to ask you just to take a very brief pause so that we can hopefully get that up and running before you continue with what Senate Bill 166 does, and then we'll move on with the rest of the committee. We can just have a bit of indulgence for a couple of moments.
Thank you for your patience, committee. Chair Scheibel, we are now unmuted to the broadcast again, and you may resume.
Thank you so much to all of our wonderful people over at BPS who help keep us going and let us know when we are having some technical difficulties and get us back up and running. Chair Scheibel, we're going to turn it back over to you. I believe you were going to get into what Senate Bill 166 does, and so we'll leave it to you and then go to committee members.
Thanks so much. And I'm sorry for the technical difficulties. Appreciate everybody's help getting us back on track. And I think I had just explained the issue using the example of a battery with substantial bodily harm with a deadly weapon, motivated by hatred or bias, and how having different definitions of that hatred or bias for a felony level crime versus a misdemeanor level crime is problematic. And it makes it difficult, if not impossible, to craft a sample or to craft a verdict form. And that's why you have the sample verdict form in the Nellis exhibits. I do want, so now we'll go through the sections of the bill. What section 1 does is it takes the language that was previously in the misdemeanor statute 207.185 and puts it in the felony statute 193.1675 so that they match. And of course, I could have done this the other direction, but there is a reason for changing the language of both statutes to reflect that the characteristics of the defendant do not have to differ from the characteristics of the victim. And this is, for example, in cases where someone commits a crime against someone of the same racial group, but a different religious group because of that intersectional identity. The crime is clearly motivated by hatred or bias. It is definitely committed against the victim because they have a characteristic that is different from the defendant, but also because they have one that is the same. And for victims of those crimes, it can be a deeply personal offense. The nuance is not easily captured in the law. There are not simply Black people and not Black people, and Latinx people and not Latinx people, and gay people and not gay people, and Mormon people and not Mormon people. To require that the state prove that the defendant and the victim have actual or perceived differences in protected characteristics can be deeply upsetting for the victim, who sees themselves as part of the same group. And so that's why I've chosen to take the language from 207.185 and add it to 193.1675 and bring them into alignment with each other. The bill does two additional things that are cleanup. Section 2 adds two different crimes into the enumerated list of crimes that can be enhanced based on the motivation of hatred or bias. The first one is found in NRS 202.448. That is making false threats of terrorism. We currently include actual threats of terrorism, but not false threats of terrorism. And the other one is found in NRS 392.915, which is the threatening to cause bodily harm or death to a pupil or school employee by means of oral, written, or electronic communication. And this was simply excluded before for no discernible reason. And if I didn't say it before, I do want the committee to know that I did some historical research on these statutes, reading minutes, watching meetings all the way back to 1989, and cannot find any reasoning for the difference between the felony and the misdemeanor statute, nor for excluding these crimes. I think it has to do with timing, different people in the legislature writing things at different times. And certainly if there is a reason for those discrepancies, I'm open to learning about them and coming to a resolution, but I couldn't find any. Section 3 makes conforming changes to the civil statutes because anybody who is the victim of a crime motivated by hatred or bias can sue on the civil side. So now all of the crimes that are included on the criminal side will be included on the civil side. And I do know that there are some groups who are still concerned about some of the language in the bill. I assure you that I am working with them. I'm open to a resolution. I do not think that this bill makes very sweeping changes to our legal structure. I think that it is a technical cleanup, but I am always happy to work with stakeholders, members, anybody who might have some ideas for a better way to tighten this up and just ensure that our statutes that govern crimes motivated by hatred or bias are tight and explicable and user-friendly. And with that, I will gladly answer questions from members of the committee.
Thank you. Thank you, Chair Scheibel. Do members of the committee have any questions? And you can go ahead and just raise your hand, and I'll go ahead and start with Senator Hansen, please.
Thank you, Madam Vice Chair. Okay, well, walk me through this then. I walk out of this building and some guy does a battery on me with a deadly weapon, and his motive is to steal my wallet. In other words, greed or robbery. The exact same crime is committed, but he does it because he finds out I'm a Mormon and he hates Mormons. Do you really believe one penalty should have an enhanced? Why am I less of a victim if the motive is greed or lust or domination or power? Why are we singling out and making special classes of victim when it's actually the conduct that we have traditionally punished? I don't see why if I'm attacked because I'm a Mormon, it should have any additional weight than if I got attacked because the motive was to steal my wallet. The end result is I get the hell beat out of me by somebody for one reason or the other. I don't get the reasoning behind this whole thing. It seems to me we're breaking down classes and groups of people and making some victims greater in value basically than others. If you could elaborate on that. You're a DA and I'm a plumber, so maybe you can make some sense of it for me.
So this is a policy question that the Nevada Legislature first took up in 1989. And that's when the hate crime statutes were first introduced to Nevada law. And it was a decision by the legislators at that time to make the policy choice to increase the penalties for crimes that are committed based on a person's race, sex, gender, religion, and other protected classes. And I'm not suggesting that we change that policy decision. I'm suggesting that we make the standards for misdemeanor crimes and felony crimes based on those motivations the same. I will also point out that there are other motivations that are particularly protected in law. Battery with the intent to commit sexual assault is a category A felony. It is punishable by 1 to 20 years in prison if the state can prove that the purpose of the battery was because the defendant intended to sexually assault the victim, even if that sexual assault is never completed. We also have enhancements for crimes that are committed against children, crimes that are committed against elderly people and other vulnerable people. So this is not a novelty in our law. It is one facet of criminal law where we have determined that there is a policy reason for making penalties more stringent for the same or similar conduct that has different underlying motivations than others.
Thank you, Madam Chair. Could I follow up? Vice Chair, excuse me. Okay,
Yeah,
well,
please.
and I can understand in some cases, but I think we're getting dangerously close to violating people's First Amendment rights when we start punishing people for thoughts that we find repugnant. I don't see why that category in particular gets so much play. It is interesting you brought up my other question, and that is now I realize that you don't want to change policy, but the reality is that's really what we do in this body. And the fact that we have a female majority legislature, it seems really ironic to me that in the policies regarding these things, we've left out the word sex. In other words, when a man beats up a woman, that's never considered a hate crime, even though I would think that would be a very legitimate thing if the man, in fact, hates women. So I'm just kind of wondering why that hasn't been added to this, as you put it, classes of people that get enhanced penalties for acts against them.
Well, because the statute includes gender identity, and gender expression, I struggle to imagine a factual scenario where the crime is committed against somebody because they are a woman, and that has nothing to do with their gender. It either has to do with them being a female by sex and identifying as such, or it has to do with them being a female by sex assigned at birth and not identifying as such. Either way, their gender identity is part of the reason for the crime. Whether that gender identity matches what we think is normal, or whether that person is cisgender, or whether that gender is non-conforming with what we think a woman should do, look, talk, act like. Gender covers every conceivable crime I can think of against somebody because they are a man, or because they are a woman, or because they are neither.
I guess the follow-up question to that would be, do you guys, I have two DAs here, do you guys routinely charge rape, people who commit rape with an additional category of hate?
No, we do not do that regularly.
Okay, well, that kind of shoots down that argument then about gender identity, because that's been in the law now for quite a while. But anyway, thank you, Madam Vice Chair. Thanks, Chair Scheibel.
Other questions from committee members? I'm not seeing any. I do have a couple, Chair Scheibel. So as I'm understanding, and I just wanted to clarify, as I'm understanding Senate Bill 166, there is currently statutes that allow for an enhancement to be charged, be it a misdemeanor enhanced to a gross misdemeanor, or a felony with an additional penalty enhancement, or what we are sort of anecdotally grouping into what hate crimes. Is that correct?
Yes, that's correct.
And so this bill does not create that enhancement organically. That already exists in our criminal laws.
Correct.
And as I understand the language here, we are conforming those two, whether you're enhancing a misdemeanor to a gross misdemeanor or a felony with an additional penalty enhancement or a term of years, that language would match between those two separate categories of enhancements.
Exactly.
I know, to me, I think the bigger question is, I think what you highlighted originally, which is the additional showing that somehow both the victim and the perpetrator must be completely different from one another in order to prove that the motive, or in other words, the reason for which a person acts, what motivates them, what prompts them to act, it has to be completely different from the perpetrator in order to prove that it was in fact motivated by a person's religion, color, race, national origin, etc.
Yes.
And this would change it so that if you can prove that a crime was motivated by those things, irrespective of whether there may be some similar characteristics between the victim and the perpetrator, the penalty enhancement still applies.
Correct.
And I guess more as a generically question, because I think Senator Hansen brings up some interesting points. It's not as though every crime that is committed against somebody because they may be different is necessarily based upon a motive for a motive of hatred, I guess, towards that person's individual characteristics.
That's correct.
And have you had instances where individuals may be of different religions and it is a robbery, but it wasn't necessarily because of that, it was just in order to steal money or something like that?
Absolutely. And if I could elaborate, in my experience, it is incredibly difficult to prove the hatred or bias enhancement. It is difficult at the charging stage, it is difficult at the probable cause stage, and it is difficult at the trial stage. The instances in which I have seen those charges sustained, I've never seen anybody convicted on one, but where I've seen them sustained are where it is clear that the victim was in additional danger and was targeted because of that characteristic, that two people were walking down the same street at the same time and somebody with a disability was targeted because they could not escape versus somebody who did not have the same disability. And those are the cases where I have seen that the hate enhancement has at least made it to a verdict form or made it into a charging document.
And I guess that was what I was trying to highlight is there may be differences between perpetrators and victims, but unless there is some kind of proof in the form of, for example, a statement that is made or a text that is sent or a letter that is provided or some other overt act by which you can prove this specific motive, it's not simply because there's a different characteristic that would necessarily entitle someone to charge an enhancement or under these statutes.
That's correct. And I think that, at least in my experience, it has been very victim focused. The question isn't I mean, it is ultimately whether or not the defendant did this because of the victim's characteristic, but you look at it from the perspective of the victim and say, did this victim experience more harm, or did they experience harm that was more intense? Did they experience harm sooner? Did they experience some greater risk of harm because of that characteristic, because of the behavior of the defendant? Did the defendant target that person because of that characteristic? And so does that put people, a class of people who all share this characteristic, at a greater threat to public safety from the hands of that one defendant?
And I guess additionally, under this statute, you would still be required that is what in particular motivated a particular crime and not some other reason.
Absolutely.
Any other questions from committee members at this point in time? And you can go ahead and raise your hand because I don't think I've got a chat open where I can see everyone chiming in. Okay, I am not seeing any. So thank you, Chair Scheibel. We are going to move to our testimony in support of Senate Bill 166, and I'm going to turn it over to our broadcast production services, and they will go ahead and prompt you if you are waiting on the line to testify in support of Senate Bill 166.
Thank you, Vice Chair Cannizzaro. If you'd like to give support testimony on Senate Bill 166 today, please press *9 now to take your place in the queue. Once again, to give support testimony on SB 166, please press *9 now to take your place in the queue. Caller with the last 3 digits, 147. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon. This is Bridget Duffy, BRIGIDDUFFY, Chief of the Juvenile Division for the Clark County District Attorney's Office. Co-Chair Cannizzaro and Chair Scheibel and members of the Senate Judiciary Committee. I'd like to place my support on the record for SB 166. I thank Senator Scheibel for adding the 2 new enumerated offenses to the list of offenses that can be enhanced as hate crimes. In juvenile court, unfortunately, children are routinely making threats to schools and to class and to certain people within schools. And I believe there was an oversight in statute because NRS 202 and NRS 392 were created after the hate crime enhancement sections of our statutes. And so when we have a terroristic threat to a school that is motivated by a person's certain race, ethnic background, religion, we are unable to notate that it is actually an enhanceable hate crime. And even though in juvenile court we do not have flat sentences, so we're never going to enhance it to the point where somebody is going to do, quote, more time because it's juvenile and we're focused on rehabilitation and making children successful in their future. It does allow us to create case plans on probation for those children and ensure that they receive the education around cultural competencies and biases, as well as acknowledging to the victims what has actually had occurred to them, because I've had cases that were clearly motivated by racial bias, and it was very difficult to let the victims know that I could not file it as a hate crime because no hate crime enhancement existed for either of those statutes. So thank you very much, Senator Scheibel, Chair Scheibel, for listening to the concerns of the juvenile system and for adding those 2 enumerated offenses, and I support SB 166.
Thank you, caller. And as a reminder, we are currently on support testimony for Senate Bill 166. If you'd like to provide support testimony, please press *9 now to take your place in the queue. Caller with the last 3 digits, 648. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Thank you, Chair Scheibel, Vice Chair Cannizzaro, and members of the Senate Judiciary Committee. My name is John Jones, JOHN, JONES, here on behalf of the Nevada District Attorneys Association. the Nevada District Attorneys Association is in support of SB 166. And we are in support of this bill because it provides clarity and conformity between our hate crime enhancement statutes, and we are supportive of the bill and the proposed amendments. Thank you for your time.
Thank you, caller. And with that, Vice Chair, there are no more callers to give support testimony at this time.
Thank you. We will then move to testimony in opposition to Senate Bill 166. Again, anyone who is in opposition to Senate Bill 166, please listen carefully to the instructions from Broadcast Services.
Thank you, Vice Chair. If you'd like to testify in opposition on Senate Bill 166, please press star 9 now to take your place in the queue. Once again, to give opposition testimony on SB 166, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 695. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin. Okay. Caller with the last 3 digits, 695. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Vice Chair Canizaro and members of the committee. This is Holly Wellborn, HOLLYWELBORN, Policy Director for the ACLU of Nevada, testifying in opposition to SB 166. We appreciate Senator Scheibel for taking time to discuss her bill with us, but our concerns remain. Hate crime statutes have a significant potential for abuse, which is why it is imperative that hate crime laws balance the sometimes competing interests of freedom of expression and thought, curbing mass incarceration, and of course, protecting against invidious discrimination. We must ensure that hate crime statutes do not extend beyond their original intent to deter crimes based on discriminatory intent. The requirement that the perpetrator have different characteristics is necessary to that end. Otherwise, we perpetuate the dangerous black-on-black crime myth and create unnecessary sentence enhancements that harm the people the hate crime law is meant to protect. Like Senator Scheibel, we looked at the legislative history, and it's also unclear to us why the misdemeanor statute failed to include the differentiating characteristics requirement. But what we do know is that the statutory construction of the felony hate crime law is in alignment with the ACLU's nationwide standards for hate crime statutes. We'll continue to have this conversation with Senator Scheibel. We appreciate her time and the time of this committee, and we hope to carry on that conversation. Thank you very much.
Thank you, caller. And as a reminder, we are currently on opposition testimony for Senate Bill 166. If you'd like to provide opposition testimony this afternoon, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 611. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Good afternoon, Madam Majority Leader and members of the Senate Judiciary Committee. This is John Piro, JOHNPIRO, from the Clark County Public Defender's Office. And right now we are in opposition. We, too, like the ACLU, would like to thank Madam Chair for speaking with us prior to this, but we do have a problem. The main problem is that elimination of the word because and taking that misdemeanor definition and moving it to the felony. It should actually go in the opposite way as a basics of legal writing. The way this misdemeanor by reason of instead of because weakens the intent element of this statute and waters it down. That can be problematic in proving things. I am also disheartened to hear Ms. Duffy speak about wanting to punish kids further when even the DOJ explains that education is the cure for these problems, because hate crimes are a problem. We cannot deny that, but education is the cure, not more criminal penalties. That's an old way of solving problems. So we disagree with taking the misdemeanor definition and moving it up to the felony level definition. Very few laws in our criminal system recognize negligence or watering down intent, and that's because we all realize that the loss of liberty is way more troublesome than the loss of money. So to weaken intent in this way is part of the reason why our nation has become a nation of mass incarceration, and it will over-criminalize things that it should not do, especially when we already have the penalties on the books. Thank you. And that concludes my testimony.
Thank you, caller. Caller with the last three digits, 130. Please slowly state and spell your name for the record. You will have 2 minutes to speak and maybe.
Good afternoon, Chair and members of the committee. For the record, my name is Christine Saunders. That's CHRISTINESAUNDERS, and I'm the Policy Director with the Progressive Leadership Alliance of Nevada. We believe that hate crime statutes are extremely important, but want to echo the concerns that were brought up by the public defenders and the ACLU about the unintended consequences of further criminalization of marginalized communities. Thank you.
Thank you, caller. And with that, Vice Chair, there are no more callers to give opposition testimony at this time.
Great, thank you. Then we will move on to testimony in the neutral position. If you are neutral on Senate Bill 166, now is the time for your testimony, and we will turn it over to broadcast production.
Thank you, Vice Chair Cannizzaro. If you'd like to provide neutral testimony on Senate Bill 166, please press *9 now to take your place in the queue. Once again, to provide neutral testimony on SB 166, please press *9 now to take your place in the queue. And Vice Chair, at this time, there are no callers to give neutral testimony.
Thank you. Chair Scheibel, any last comments that you wanted to share before we close out the hearing on Senate Bill 166?
I want to thank the committee for their time and reiterate my willingness to keep working with groups who are in opposition to the bill and see if we can come to a place where we can agree.
Thank you so much for being here and presenting Senate Bill 166 today. With that, we will close the hearing on Senate Bill 166. And Chair Scheibel, I will turn the gavel back over to you.
Thank you so much, Vice Chair and Majority Leader. That takes us to the next item on our agenda, the BDR introduction. Pursuant to Senate Joint Standing Rule 14, committee members must vote to approve the drafting of legislative measures requested by the Senate Committee on Judiciary. Please remember, a vote in favor does not indicate your support for the bill, but merely allows the bill to be drafted. Today, I request the committee's approval of one bill draft, BDR 10-1019, which revises provisions relating to insurance coverage for certain common interest communities. Are there any questions about the BDR? I see one from Senator Pickard.
Hey, Madam Chair. I noticed that we're exempting in the bill townhomes and duplexes. There are a number of developments in my area that are made up of multiple townhomes and duplexes, and I don't know that we want to exclude them. Is there some discussion about maybe making those based on size or the number of total units within that HOA?
That's certainly something we could discuss when we get to that policy discussion on the bill. I think at this juncture, we're just asking whether or not we want to draft this bill in order to consider it. And Senator Orenshaw.
Chair, if the chair is ready, I'd make a motion for introduction.
Thank you so much, Senator Orenshaw. I have a motion to introduce BDR 10-1019 from Senator Orenshaw.
Second.
And a second from Vice Chair Cannizzaro. Any discussion on the motion? Not seeing any, we will go to a roll call vote. Will the Secretary please take the roll?
Vice Chair Cannizzaro?
Yes.
Senator Orenshaw?
Yes.
Senator Harris?
Yes.
Senator Settlemeyer?
Yes.
Senator Hansen?
Yes.
Senator Pickard?
Yes.
Chair Scheibel?
Yes. And with a unanimous vote, the motion passes to draft BDR 10-1019. Thank you all very much. And that leads us to the last item on our agenda, which is public comment. Mr. Kyle, could you please see if there's anybody here to give public comment?
Thank you, Chair Scheibel. If you'd like to provide public comment this afternoon, please press *9 now to take your place in the queue. Once again, to give public comment at this time, please press *9 now to take your place in the queue. Caller with the last 3 digits, 556. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIE. Good afternoon. I would like, my brother Thomas Purdy was 38 years old when he was hogtied by Reno police officers David Tallman, Robert Maxwell, Christopher Good, and Jorge Aparicio during a mental health crisis when he was a guest at the Peppermill Casino and simply asked security for help. My brother was hogtied for 40 minutes when he was non-combative, non-assaultive, and again, simply asked for help during his mental health crisis. 40 plus minutes later, he was dumped at Washoe County Jail, still hogtied, begging for his life. They thought my brother was acting so strange. They got a handheld camera, yet they didn't get him an ambulance like he asked for, told him he couldn't breathe, told him he was going to die, told him that he had had previous major lung surgery, which he had had a collapsed lung. This happened on October 4th, 2015. My brother died on October 8th, 2015, when we had to remove him from life support because he was brain dead. Washoe County Sheriff's Office never tried to notify my family that my brother was at the hospital on life support. My brother lay there alone, brain dead, for 2 days, until the hospital was able to locate my family. When my brother was asphyxiated to death by Reno Police, Washoe County District Attorney Chris Hicks did not even review his case, nor does he review any deaths at the hands of law enforcement in Washoe County if the method of killing is asphyxiation by officers. Per the Washoe County Medical Examiner, my brother would not have died were it not for the physical force used on him by police officers. My brother weighed 140 pounds, soaking wet. He died uncombative, having assaulted nobody, simply asking for help. Please do not support bills that provide further protections to law enforcement. Please support bills that provide accountability and transparency from law enforcement, and bills that protect community members from police who choose to abuse their authority. Thank you.
Thank you, caller. And as a brief reminder, we are currently in public comment, and if you'd like to provide public comment this afternoon, please press *9 now to take your place in the queue. Caller with the last 3 digits, 490. Please slowly state and spell your name for the record. You will have 2 minutes to speak and may begin.
My name is Cyrus Hojati, CYRUS-HOJJATY. So it seems like there's a lot of division and there's a lot of finger pointing at one side to another. I think that our society, our country is going through a very rough path, high levels of income inequality. I mean, I read a lot of articles saying that Jim Murin, the former CEO of MGM Resorts, has profited greatly from the COVID shutdowns. The rich people keep getting richer. I don't feel that our government, either party, represents the true voice of the people. I think that tensions among one group or another, which can happen from anybody, believe it or not, is only going to increase. And if you guys feel that one person is the instigator, then for heaven's sakes, do us all a favor and maybe we should just break up the country. We can't get along. This is just going nowhere, and it's just fighting one after another. Riots, civil unrest, just double standards, just saying us what we can say, what we should say. You know, just a lot of tension, a lot of division. Let's just break up, and let's just go on our own merry ways. Let's have our own responsibility. And as for myself concerned, I don't know, man, probably consider moving to another country. I mean, this country has really gone downhill. And it's not just a matter of the division. It's just a corporate fascist state. Nevada is a state that is controlled by casino, labor union, and real estate elites. It doesn't represent the people. The urban planning is a sham. You go to all these other states around the world, it's so much better. And look at the family structure. We have destroyed our family structure. So do us a favor. Let's just break up the country. It's just too large to manage. There's just so much division. And I think we will see how things will go.
Thank you.
Thank you, Chair Scheibel. And with that, the phone lines are open and working. However, there are no more callers to give public comment at this time.
Thank you so much. That brings us to the end of our meeting. We will be back tomorrow at 1 p.m. We have 2 bills to hear tomorrow. And with that, we are adjourned.